Do you own a semi-automatic gun? If so, then you need to watch this because a federal court just said that magazines are not protected under the Second Amendment. What does that mean? Let's take a look in this video. The case is Ocean State Tactical v. Rhode Island. And yes, this does only have to do with the Rhode Island law that was just recently passed and enacted, which basically rules out all normal capacity magazines, or as they call them, large capacity magazines, or LCMs. We're of course talking about those evil devices that hold 11 rounds or more. So if you live outside Rhode Island, why should you care? Because the reasoning utilized by this judge, the reasoning utilized by this court can and will travel. This is the same type of arguments of reasoning that can be used in your state, wherever you are. This is the same type of reasoning that will be advanced at all different levels of federal and state court. So it's going to be important to understand, what are you up against? What are we all up against? And what can we do about that? So let's take a look at what's going on here. So an FFL and 4 gun owners basically sued, saying, look, this is unconstitutional, and this is also an illegal taking, because of course, all the magazines that are 11 rounds or higher, they're not grandfathered in under this law. They appear to have some sort of either irrevocable conversion, or they need to have some sort of turn-in without any kind of compensation. So again, we have a constitutionality issue of, look, magazines are protected underneath the Second Amendment. That does not exclude 11 rounds in larger magazines, such as, of course, a Glock 19, 15 round, 17 round magazines, all that kind of stuff. Those are all protected under the Second Amendment. Rhode Island is saying, no, it's not protected under the Second Amendment. So the court has to go into basically a discussion in a post-New York Rifle State Pistol Association v. Brune world, where they have to go through a historical analysis. Remember, that was one of the absolute huge impacts of that case coming out from June of 2022. New York Rifle State Pistol Association v. Brune is among the many things that it said is it did away with any kind of intermediate scrutiny analysis. And yeah, I understand this is boring for some of you, but this is super important stuff. This is super important stuff because this is how cases get decided. There's different levels of scrutiny. The higher it is, the harder it is to pass a law to interfere with something. And basically, every single core constitutional right, including the amendments, got the highest level of scrutiny, except, of course, the Second Amendment, which basically got something amounting to a bastardized two-step, much lower level of scrutiny. And one of the absolute biggest long-reaching implications and impacts of Brune was saying, no, not doing that. Instead, we now have a unique historical tradition analysis, where if any kind of legislator or if court who's analyzing something is looking at a law that goes towards a core Second Amendment activity, there has to be a justified rationale coming out of historical tradition and analysis. So you can't just be using something and saying, well, this state did it over here, or we did this a couple months ago, or a couple years ago, or even a couple decades ago. No, it has to come from basically a combination of either looking at United States law as well as English common law that arose prior to that. For those of you who may not know, what is a magazine? Well, super briefly, a magazine is a device that holds extra ammunition and it gets inserted into a firearm. So, of course, a firearm without ammunition isn't going to be much good. And most of the firearms sold today, I think upwards of about 80%, according to a recent ATF analysis, are going to be semi-automatic firearms that are sold, meaning that they have to come with some sort of magazine. Sometimes it's an internal, sometimes it's an external, but generally they're almost always external these days. In other words, it's something that's detachable, comes out, can be loaded, and then or a fresh one reinserted. This is something that all police officers carry everywhere. Everybody in the military carries. This is it. This is where technology has brought us to. So the first question the court has to say is whether or not these magazines are actually protected under the Second Amendment. The court says no. And when they are discussing this in their brief, they basically say the reason why it's not protected is, well, a couple things. One, they say that, look, the only real way, because they did note that some courts have said that, no, look, magazines are protected. But the court said, look, the way that courts get there, the way that these other courts get there, these, of course, lesser courts get there by implication, is by comparing magazines to bullets. Because after all, a firearm without bullets isn't really a firearm in the sense that it can fire anything. It's like a car without any gas, or for you Tesla owners, without any electricity. It can't go anywhere. It can't do anything. It's just an inanimate object, which, by the way, that's all it is anyways, but that's really kind of a separate discussion. Well, they go on to say, look, at the end of the day, without bullets, and I'm quoting from page 28 of the decision, without bullets, a firearm would be useless, but a firearm can fire bullets without a detachable magazine. And in any event, a firearm does not need a magazine containing more than 10 rounds to be useful, end quote. Again, not my words, the court's words. So what the court is saying here is, look, a firearm's still a firearm, even when it has 1 round, 2 rounds, 3 rounds, 4, all the way up to 9 or 10 rounds, and it can still be useful performing its duties and its service in self-defense. Therefore, at the end of the day, a magazine, really not part of the firearm. It's really not essential to the use of a firearm, and therefore it really isn't a weapon. But the court goes on from there, and it actually winds up drawing a distinction between arms, and of course, the definition of the Second Amendment, the literal text of the Second Amendment, keep and bear arms. So arms is a very important word, so the court's using actually a professor of linguistics who basically says, look, there's a distinction to be made here when we're talking about arms, and again, their words, not mine, but accoutrements. So the court draws a distinction using the professor of linguistics. On the one hand, arms which are going to be protected, rifles, pistols, knives, swords. What is not protected are these accoutrements instead. So we're talking about the ammunition, the cartridges, the containers, all that kind of stuff. Holsters, scabbards, and so forth. Now, of course, let's just pause for a moment to recognize the fact that extending the logic of the court, you do not have a constitutional right to a holster. You do not have a constitutional right to really something that's going to be able to allow you to transport this weapon around in anything resembling a safe manner. So again, this is a very, very, very insidious line of reasoning because it has such long-reaching implications and impact for where this could travel to, all right? And I'm going to get into that moment. But for now, let's just keep powering through this decision, all right? So look, really a magazine is not an arm, and you don't need a magazine for a firearm to be useful, again, according to the court, not according to me. So at the end of the day, magazine, it's not an arm, therefore it's not part of the Second Amendment. But what about, can a magazine be used for self-defense? So the court goes on. So the court relies on 2 lines of reasoning here. And again, you can find this directly in the decision. It's about page 33, 34, 35, somewhere in there. First, the court noted one of the state's experts that filed a statement as part of this case, who is the chief of the Rhode Island Bureau of Criminal Investigation and, conveniently enough, a former ATF agent, who wrote that in all of Rhode Island's history, he was unaware of any civilian self-defense shooting where someone used as many as 10 rounds in self-defense. Okay, so apparently, again, I don't know if this is true, but this is what they're saying is true, and God, internet, please help me. If you can find some sort of citation where this is not the case, by all means, please post it up in the comment section below. But for the time being, the chief of the Rhode Island Bureau of Criminal Identification is saying that there's never been in the history of all of Rhode Island a use of firearms in self-defense that required as many as 10 rounds or more. All right, so the court's relying on that. We'll also note that something the court also pointed out is that the same individual went on to say, look, and by contrast, while good guys never shooting 10 rounds, bad guys, well, in contrast, criminals frequently use large capacity magazines in the course of their criminal conduct. Right. So this is basically a weapon of bad guys. That's what the chief is saying. So here we have another professor, this one of about the Civil War era, who actually went on and said that high capacity firearms during the era of the Civil War were understood to be weapons of war or anti-insurrection, not weapons of individual self-defense. And again, that's about page 33, 34 of the decision. In other words, high-capacity firearms during the Civil War, those were bad guy weapons, and no one legitimately possessed them in self-defense. What were high-capacity weapons during the Civil War? Because again, when the Second Amendment was written, we didn't have things like revolvers, all right? We didn't have anything like that. A high-capacity weapon in the Civil War, we're talking about lever guns, we're talking about revolvers. That was a high-capacity weapon back then. So I think there's a lot of what's going on here is reading back into this what we want to see, or I should say what the court wants to see, as far as what are the definition of high-capacity weapons. Because of course these days, I don't think I've ever seen anybody describe a 6-shot revolver as a high-capacity weapon. That's almost the definition of a low capacity weapon, right? Likewise, same thing for lever guns, something where you've got maybe a 38, or well, at the time you got all the Civil War cartridges and calibers, but something that may have carried anywhere from say 6 to 10 rounds back then would have been an extraordinarily high capacity weapon. But these days, again, that's really not all that much. But the court ignores all of those facts. The court does nothing with those facts. And it just goes on to say, look, at the end of the day, good guys don't use them, bad guys use them, bad guys use them now, bad guys use them back then, and therefore they have no self-defense value. And since they have no self-defense value and they're not weapons, they're not protected by the Second Amendment. That's it. That's their reasoning. That's how they got there. Yes, it is that simple, apparently, at least in Rhode Island. And don't be surprised if, of course, that line of reasoning is going to be in many other states as well. The second issue that the court had to resolve was whether or not there was a taking involved here, because, of course, we're going to be taking away all these different devices that people have been purchasing, namely magazines, or at minimum forcing people to convert them. And we're assuming that, of course, they can be converted. And basically, the court said, look, if something is being done to property that's in the public interests, and again, I'm super simplifying this, and that property could be injurious to people. It could be basically kind of bad stuff. That's not a taking. All right. So there you go. On the one hand, magazines are not covered by the Second Amendment because they are neither arms nor can they have any kind of legitimate self-defense use. And on the other hand, of course, taking them and destroying them, that's not illegal because only bad guys have them, both now as well as in the past. Wow. So, of course, this bears some analysis and some looking at. If we were to extend the same line of reasoning to the First Amendment, and I'm a big fan of doing this kind of thing because it makes things easy to understand, number one, for folks who may not really understand lots of firearm issues, and to put it into a more contextually easier way for folks to grasp at. And number two, just because that's me, I use analogies, I use metaphors, it's just kind of what I do to break things down. But let's imagine if we now had this judge doing the same thing to the First Amendment, because in essence, what this judge is saying is, look, as long as you have a firearm that can fire, enough rounds to be useful, and I've decided that that number's 10 based on, what this one chief has said, and only in Rhode Island, because of course, what has only ever happened in Rhode Island, and never mind the other 49 states, that's what will only ever happen in Rhode Island. And I'm very glad for the folks of Rhode Island that they only now have to use 10 rounds or less in order to be useful and effective in self-defense. That's, of course, fantastic to hear for this judge. That's great news that all bad guys will be stopped with 10 rounds or less because of this judge. But look, if we take this logic and start applying it to the First Amendment, what does this mean, right? Because basically what this judge is doing is ignoring the march of technology and progress as time has moved along to see the ongoing expression of the Second Amendment. Because, of course, the ongoing expression of the Second Amendment has really nothing to do with a particular number of, say, 1 round or something like that. The ongoing expression of the Second Amendment is to be able to defend yourself against bad guys, whoever those bad guys might be. Period. That's the way of doing it. In order to do that, you need to have, at a minimum, an equal playing field to those bad guys. Now, of course, bad guys are happy to break the law. That's part of what makes them bad. So who do you think in Rhode Island or any of these other states are going to be having these magazines, the large capacity magazines? The good guys or the bad guys? Right, the bad guys, because they don't care about this kind of stuff. I've got a great video coming on that, hopefully very soon. I'm working on that right now. And fundamentally, the march of progress has to do with making more effective bullets, more reliable firearms that can basically put out more bullets more quickly, because that's the best way of stopping a threat. That's it. So how does this all tie back into the First Amendment? Well, ignoring the march of technology, then I guess, in order for someone to usefully use the First Amendment, we really don't need modern book bindings, right? That just allows people to read more pages, and really only a handful of pages per hour or per day. That's good enough, right, Judge? Likewise, Kindles, computers, iPhones, really the internet in general, that's all unnecessary. People don't need to access that much information to be informed. People don't need to be able to access that much information this quickly in order to have a useful political opinion, right? What about if we take a look at something that is not constitutionally protected? Say, a vehicle, right? Well, you really only need to have an effective range of, say, let's look at how far an ordinary person drives per day. Maybe a handful of miles. So, in order to be useful, a car only needs to have, what, say a 1-gallon gas tank, right? 1 gallon should be more than enough to get you to work, school, back home, or something like that. Maybe 2 in certain areas. But in order to be useful, that's really all you need. Because apparently that's, again, what this judge is going off of. And extending the logic, that's what your judges may be going off of too, depending upon the state that you live in. So to be clear, this was a motion for summary judgment that was basically denied. So what will probably happen now with this case is it's going to be ongoing, and we're probably going to see a discovery phase and all that kind of stuff. And of course, the plaintiffs, in other words, the 4 firearm owners as well as the FFL, will hopefully, if they don't get the kind of relief that they're looking for, will take this up on appeal and it will get progressively more attention. But folks, this is exactly the kind of stuff that we need to be looking out for. Because of course, what the judges are doing is they're saying, fine, we have no choice but to accept the fact that the US Supreme Court said this is how we need to interpret this. But they're going to do every last thing in their power to throw out everything that they can so that they can basically reach the decisions that they want to. Oh, magazines, holsters, all that kind of stuff. You know what? It's not useful. Only bad guys use it. Why? Because I got this cop who said so. All right. That's why. So folks, I'm sorry to say this is where we're at. This is where obviously we're going to be going until, God willing, the U.S. Supreme Court steps in again and does so in a favorable way, consistent with actual historical analysis and tradition. If you like this video, please click thumbs up. Again, this really helps us with the YouTube algorithm. Please click thumbs up. And of course, subscribe for more great videos. We've got a lot of great things in the pipeline. I'll see you in the comment section. Let me know what you think about this. Let me know what your states do as well. If you're in a state that has some sort of capacity restriction, has there been litigation on that? Is there something that you want me to take a look at as well? We'll see you in the next one.